The audio is working. Cool.
Tell us when you click go and we will rock and roll.
It's been clicked.
Are you ready?
Yeah.
It's recording.
Okay. Say you are the king or queen of a great kingdom. You love your son, but he's a spoiled brat. One day, he steals food from the kitchen staff, lets the horses escape, and pours wine on all of your powdered wigs. How would you correct this spoiled prince? Surprisingly, throughout history, real kings and queens didn't know how to do this, and what they ended up doing was having another boy whipped in front of the prince to teach him a lesson. These misfortunate children were known as the whipping boys. Now, the prince was not allowed to be punished according to the law, so he never learned and he never changed his ways. This was an ineffective form of punishment. Effective punishment focuses on the person who did the wrong, but this hurt an innocent person and failed to correct the perpetrator. As society has advanced over the years, you would think that we'd leave a flawed practice such as this behind and learned how ineffective it was. However, this exact practice exists in U.S. criminal law today, a law that seeks to punish police officers by making society the whipping boy. This law is known as the exclusionary rule. The Founding Fathers created the Constitution as a way to protect American rights and to keep the government limited. The most relevant section of the Constitution for today's discussion is the Fourth Amendment, stating that no warrants shall issue but upon probable cause, describing the things to be searched and seized. As the U.S. grew, new laws were written that were separate from the Constitution that established the criminal procedure. These rules were dubbed the Federal Rules for Criminal Procedure, or the FRCP, and were first adopted in 1944. However, there are many rules produced by court decisions that are not written in the FRCP. In 1967, the Supreme Court established the exclusionary rule, which states that all evidence that was found in any illegal way is completely barred from court. This was decided in the case of Mapp versus Ohio. If the police do anything illegal while searching for evidence, that evidence gets thrown out. To better understand the intended effect of the exclusionary rule, we must look at the reason for its origin. The case of Mapp versus Ohio occurred when police illegally entered the home of Dalry Mapp without a warrant and found child pornography in the house. Mapp and her attorneys successfully succeeded in getting the evidence excluded from court. And a majority opinion authored by Justice Tom C. Clark declared that all evidence obtained by searches and seizures in violation of the Fourth Amendment are inadmissible in a court of law. Now, this decision created a broad rule that has now grown so that it applies to almost all cases of police mistake and misconduct, not just the Fourth Amendment. The intention was to stop police from acting beyond their jurisdiction and to keep them from being grossly negligent. Gross negligence is legally defined as the intentional disregard for people's rights and safety. The exclusionary rule was meant to be a protection of American rights, but it does nothing to fulfill its intended purpose. The exclusionary rule should be an exception, not a rule, only to be applied in cases of police gross negligence or repeated misconduct. In support of this, I'll direct your attention to three major arguments. First, the exclusionary rule is an ineffective form of punishment that does nothing to correct or deter the police. Second, it's too broad in its application. And third and finally, the exclusionary rule fails to fulfill the purpose of the criminal justice system. Let's first address the topic of punishment. Police are responsible for keeping communities safe and enforcing the law. They should be respected and honored, but the police are not above reproach. The exclusionary rule was made to directly address the issue of police abusing their power. Indirect punishments are ineffective. Looking to the example of whipping boys, the prince was not corrected and an innocent person was hurt. This is an indirect form of punishment. The exclusionary rule falls into the exact same trap. According to attorney Marcia Shine, quote, because the exclusionary rule in one case does not deter police from going right back out and violating someone else's rights, the rule fails to effectively address the issue of overreaching law enforcement and unreasonable searches and seizures, end quote. Not only is it an indirect punishment, the exclusionary rule is also an ineffective deterrent. Police officers generally are not thinking about whether their evidence will be excluded when they are searching for evidence. A recent study done by Columbia law students reasoned that if the exclusionary rule was effective in deterring unreasonable police action, there would be a decrease in the motions to suppress evidence. According to Craig Diuchida, writing for the Journal of Criminal Law and Criminology, quote, "The results indicated a significant increase in the motions to suppress for narcotics and weapons offenses," end quote. These are the most common crime cases that involve searches and seizures. In other words, police violated privacy more when the exclusionary rule was ratified. What proves this even further is that according to Gallup polling, there's a massive issue with police misconduct in the United States, and accordingly, confidence in the police reached a 22-year low in 2015. If the exclusionary rule was effective, we would see less police misconduct and higher confidence in the police. However, it does nothing to help officers right their ways. It does nothing to punish officers who clearly misconduct themselves, and it does nothing to promote a more effective and efficient police force. The exclusionary rule doesn't fix the police like the Supreme Court hoped it would. The root of the issue really lies in the way that police are trained and treated. In the US, police training lasts on average 22 weeks. That's less than half of a year. In Europe, that would be unthinkable. In Germany, for example, police train for at least 130 weeks. That's almost 3 years. Even in life-threatening situations, police conduct around the world is better than America's. According to the Christian Science Monitor, a highly reputable news organization not to be confused with the Christian Scientist religion, British officers shot their guns 51 times between 2003 and 2013. Canada averaged around 12 fatal police shootings each year, and in 1990 to 2009, and in Japan, nobody has been shot by the police since 2012. In 2016 alone, the United States had 400 fatalities from police gunshots. That's almost 80 times more than England, 33 times more than Canada, and 400 times more than Japan. Of course, there are multiple factors that play into this. However, even when you factor in population, culture, crime rates, these numbers are still staggering. All of these countries have limited exclusionary rules, and they properly train their officers, and they correct them for their misconduct. Why would America not follow this example to train and correct its officers more efficiently? Training and correction are clearly more effective than throwing out crucial evidence. The US relies on the exclusionary rule to magically fix the police, and it's failing. You have to correct wrongdoing. If someone is caught speeding, they're required to take defensive driving so they don't make the same mistake again. If police make honest mistakes, they should be trained not to make that mistake again. If the officer violated the Constitution but didn't recklessly endanger the rights or lives of the people affected, he should be sanctioned or fired. These are direct forms of punishment that would actually address the issue at hand. The exclusionary rule is too broad in its application. Sweeping solutions, when used to fix specific problems, cause more issues than they solve. Think of it this way. If one apple is bad, it would be generally bad to throw all of the apples out. Doing that would be far too broad of a solution. Now, going back to the topic at hand, the exclusionary rule falls into the same trap once again. In the case of Mapp versus Ohio, the police intentionally entered the home of Dalry Mapp without a warrant and searched with no justification to do so. In this isolated instance, the police were grossly negligent because they threw Mapp's rights out the window. It made sense to exclude the evidence in this case. However, the Supreme Court made a big mistake in their decision. They established the nationwide exclusionary rule that applies to all cases of police misconduct. This broad nature creates two bad situations. First, most of the cases where the exclusionary rule is applied do not deal with gross negligence. Mapp versus Ohio was a bad apple, but several other cases where evidence was crucial have since been affected by the encompassing nature of the exclusionary rule. Take, for example, the case of California versus Minjares, where courts decided that police had enough probable cause to search the car, but not the bag and the trunk. The police had no way to tell that in the moment, but the stolen goods that were in the bag were excluded from court. Or the case of Patney versus United States, where the ex-felon Patney interrupted and stopped a police officer who was reading him his Miranda rights by simply saying, "I know my rights." The courts decided that because the officer did not finish reading the suspect his rights, all testimony and the illegal gun that was found from the interrogation were to be excluded. These two cases represent the nature of how the exclusionary rule is used in court. It becomes a defense for criminals because the police officers have made mistakes. It should only apply when the police were intentionally disregarding the rights and safety of others, not when the police make an honest mistake while carrying out their duties. Second is that exceptions to big rules cause big problems. Sidesteps to the exclusionary rule are akin to blowing a hole into the only wall that protects a city. This is shown by the major exceptions that the Supreme Court has been adding to the exclusionary rule that negate and almost nullify existing laws. The most relevant example is what's called the knock and announce exception, where when entering a home, police are required to knock on the door, announce their presence and intention, and wait 20 to 30 seconds before entering the home. This is an important standard because it prevents police from simply raiding every home they need to search. In 2006, the Supreme Court was presented with a case where police made a mistake in following the knock and announce rule. The defense was using the exclusionary rule to try and keep the evidence of drugs and weapons found in the search out of the trial. The Supreme Court, however, did not want to exclude the evidence because they saw it was critical to the prosecution. Finally, a glimmer of hope. But Ronald Reagan once said, quote, "The most terrifying words in the English language are 'I'm from the government and I'm here to help,' end quote." So in classic governmental fashion, they made an even bigger problem by saying that knock and announce violations never trigger the exclusionary rule, essentially removing the knock and announce standard. The exclusionary rule is simply too broad. It allows for crucial evidence to be thrown out, and its exceptions nullify other more important laws. Finally, the exclusionary rule fails the purpose of the criminal justice system. Imagine you're the parent of a 14-year-old girl. Your daughter, who you love so dearly, is kidnapped and brutally murdered. The murderer is caught, and there would be nothing more right in your mind than to bring this despicable criminal to justice. To your horror, however, you listen in shock as the court, that is supposed to be committed to serving justice, decides to set this felon free. Imagine the agony you and your spouse go through as you see this man who killed your daughter freed due to clerical mistake by the police. This is not hyperbole. This exact case happened in Coolidge versus New Hampshire and is the direct result of the exclusionary rule. The Coolidge case highlights that the exclusionary rule fails to uphold justice and thus fails to fulfill the very purpose of the criminal justice system. According to the Center for Crime and Justice Studies, quote, "The purpose of the criminal justice system is to deliver justice for all by convicting and punishing the guilty, helping them to stop offending, and protecting the innocent," end quote. The exclusionary rule seeks to protect the innocent. However, it fails to uphold the purpose of the criminal justice system in two ways. First, it doesn't deliver justice for all. In the case of Coolidge versus New Hampshire, Edward Coolidge was convicted for murder and rape of a 14-year-old girl named Pamela Mason. However, the police simply obtained a warrant from the wrong person, and the body of Pamela Mason, along with all the other crucial evidence, was excluded from trial. The murderer, Edward Coolidge, did not serve the life sentence that he was originally sentenced to, and he is free to assault others today because of the exclusionary rule. It inherently bars crucial evidence from being shown to the court. The result is that the criminal often does not get convicted, and therefore he or she is not held accountable. The result is that the court fails to serve justice with the exclusionary rule. Second, it actually endangers the innocent. Criminals are a danger to society. If they are set free due to inadmissible evidence, that means less safety in society. Judge Frank J. McGarr, writing for the Northwestern University School of Law, stated that, quote, "In my experience as a prosecutor, I frequently saw guilty persons released to prey on society again because of the operation of the exclusionary rule," end quote. This is statistically true as well. A study written by Raymond A. Atkins and Doctor of Economics Paul H. Rubin showed that in the years following the exclusionary rule's nationwide mandate, crime rates in states that previously didn't exclude evidence showed significant increases. Some rates increased as much as 30% for assault. The causation that was stated in the study for this increase was that police officers started using less effective methods of conviction as a substitute for searches and seizures. This was due to the exclusionary rule making it more difficult to use evidence, because if any mistake was made, the evidence was thrown out. In more simple terms, the police were afraid that their evidence would be excluded, so they didn't risk large searches. Growing crime rates have become so prevalent that, again, according to Judge McCarr, quote, after World War II, the incidence of crime has steadily increased in the United States at a rate more rapid than the increase in population, end quote. While the exclusionary rule is not solely to blame for this, it has done nothing to help slow this growth. The exclusionary rule harms the innocent because it punishes society for police mistakes. Therefore, it fails the purpose of the criminal justice system. The late Justice Benjamin Cardozo, an extremely respected justice in the 1930s, put it best when he lamented that excluding evidence, quote, allows the criminal to go free because the constable has blundered, end quote. Edward Coolidge should not have gone free. Justice for the death of Pamela Mason should have been served. And when interviewed by the United Press International, David Mason, Pamela Mason's father, buried his head in his hands and said he was trying to control his anger. The exclusionary rule obstructs justice and therefore does not fulfill the purpose of the criminal justice system. It's necessary to address some concerns. You're probably worried about your privacy. I have 3 reasons why privacy will not be lost. First of all, the idea that the exclusionary rule protects privacy is empirically denied. The exclusionary rule is a fairly recent law, having only been put in place in 1967. Before it was nationwide, the United States still had high respect for privacy, and police didn't burst into homes even without the exclusionary rule. This argument can also be refuted by looking at other developed countries. Craig M. Bradley, an expert in comparative criminal law at the Indiana University, stated that, quote, foreign countries have flatly rejected our approach. It's up to the trial judge to decide whether police misconduct has risen to a level of requiring the exclusion of evidence, end quote. Canada is an excellent example of a limited exclusionary rule in action. According to the New York Times, Canada has allowed evidence even from, quote, brazen and flagrant searches into court, end quote. Canada, however, has far lower police misconduct than the US. According to the Wilfrid Laurier University, police in America are 6 times more likely to use lethal force than Canadian officers, and 67% of Canadians respect and trust their police compared to the US's 52%. Japan is also a country with a limited exclusionary rule, and according to Business Insider, Japan is one of the safest countries in the world. Remember, Canada and Japan do not have exclusionary rules, and the idea that the exclusionary rule is the only way to stop abuse of police is denied empirically. My second response is that privacy is one of the priorities of the criminal justice system in America. The Bill of Rights specifically places privacy over the law enforcement's ability to search and seize. The majority of officers in the U.S. are committed to serve and protect the communities. And the United States Foundation is built upon the respect for human rights, and that foundation is built on the rock of the U.S. Constitution. My third and final response is that the exclusionary rule does little to nothing to protect your privacy in the first place. This has already been proven by my case. Privacy violations increased once the exclusionary rule was mandated, as seen in my second contention. The final topic to affirm is that redefining the exclusionary rule would solve the current issues. The problem created by the exclusionary rule is caused by the fact that it is a rule. Defining it as an exception would make it more precise. This would solve the problem of police mistakes obstructing justice. These cases wouldn't be extreme enough to warrant exclusion. Instead of villainizing the police for making mistakes, and instead of punishing society for their blunders, officers could be trained and corrected more effectively. Making the exclusionary rule an exception would allow it to fill its original purpose by allowing it only to apply in cases of gross negligence and repeated misconduct. And in those cases, it would only stop what it was supposed to stop. Now, there's a flawed mindset that plagues a large part of American society today. And that belief is that the police are evil and are there to hurt Americans and their rights. The exclusionary rule does nothing but affirm this disdain. Police are not perfect, and they're not above reproach, but they're certainly not criminals. The exclusionary rule treats the police as being more dangerous than criminals. The law can no longer be allowed to push this narrative. What we see is that criminals should never go free because of crucial evidence being excluded. Justice requires that criminals are punished. Justice requires that innocent people are protected. And justice requires that the truth is heard in court. Proverbs 21:15 reads that, quote, "When justice is done, it is a joy to the righteous and terror to evildoers," end quote. The law should never stand in the way of justice, which can only be achieved if the exclusionary rule was made into an exception. Thank you. All right.
Go ahead and get a drink if you want.
Cool.
Take a moment.
I have not, I've been your leadership teacher for a year, and I've not had the chance to hear your oratory skills, and I've heard about them, and they are excellent.
Thank you.
Good job. Really good job. You want me to ask a question? Okay. Elliot, have you heard the phrase fruit of the poisonous tree?
Yes, I have.
Can you explain it, please?
Fruit of the poisonous tree is essentially like if something was not done correctly in the search, then all of the evidence that was found due to that search preceding the mistake is what is known as the fruit of that poisonous tree. So basically
all
that
the fruit
evidence,
is,
most of the fruit that follows that mistake in the search or the process is what's excluded, because
Okay.
that's what's called the fruit of the poisonous tree.
okay. Did you run across any case law that, I'm actually sure you did, but give me an example of case law that illustrates your point that we should allow fruit of the poisonous tree to come into examples.
So-
to come into,
Like specific case laws,
well,
or
just in
like
your research.
examples
Yes.
of? So basically, what I'm saying is that when the police are intentional about their violation of people's rights, or when they're, quote, grossly negligent, that's when that fruit is actually poisonous.
Right.
And what I'm saying is that when the police just make a mistake, that fruit isn't poisonous because the police weren't intentional in their violation of people's rights. They weren't intentional in the mistake in the process. So, in the cases where I talked about, especially Coolidge versus New Hampshire and California versus Menendez and Potney versus U.S., all of those cases were where this person was clearly a criminal. They had evidence of pretty egregious crimes, but it was all excluded because police made a mistake.
Okay.
Especially in Coolidge, it was a very minor mistake. They just got a warrant from the wrong person. Every other bit of process was followed. But due to that philosophy of the fruit of the poisonous tree, all of that evidence was not allowed in court.
So would you say not all the fruit would be poisonous, or not all the tree would be producing poisonous
I'd
fruit?
say that it depends on the tree.
Okay.
Yeah.
Okay, thank you.
So one of the things that we have long debated is whether the memory requirement is actually essential.
Sorry, what was that?
One of the reasons that we've debated, this is not a question, this is just me talking
Oh,
to you.
okay.
One of the reasons we've debated the memory requirement, and we've said it's essential because people who read do not present well, and you just presented fantastically,
Oh, thank
even
you.
while reading. You proved us wrong. If everybody did it like you did it, we may get rid of the memory requirement, so great job.
Thank
Well
you.
done. So my question, I think it is likely going to become a line of questions, but the first one is, can you tell me the process that a policeman is required to go through in order to ensure that the evidence is admissible into court?
Okay, so like the whole process they have to go through?
And
To
it may be different in different circumstances,
Yeah.
so maybe just give me an example.
So if it was a case like a home search, the police would have to present probable cause to a trial judge or any sort of magistrate for them to authorize a warrant for the policeman to then go search the home. And then they can use the evidence that was described specifically in the warrant to then present that in court. They basically have to say, I'm searching for drugs, I'm searching for guns. And if they find drugs and guns with a valid warrant, they can use that in court. But if a police officer gets a warrant for, say, weapons, and they go in and find something that is not described in the warrant, they would have to get a warrant for that item before they can use it in court. So that's generally the process for like a home search, which is a pretty common type of search.
Okay, and would you be, you're not proposing any changes to that,
No.
just to, if a police doesn't follow that, determining whether it was gross negligence or intent?
Well, yeah, like if a police officer, there's actually a lot of different standards that apply to the situation. In some cases, police can enter a person's home without a warrant, and those are what's called the exigent circumstances. there's several situations where that can be allowed. Like if they're in hot pursuit of a criminal and the criminal runs into the home, they can enter the home without a warrant. Sometimes police can defend their action by saying it was exigent circumstances. But that's where it would really come down to defining and finding out if the policeman just made a mistake in the process, or if they were seriously or if they were being grossly negligent. Obviously, if they just disregarded the warrant requirement with no reason, then that wouldn't be warranted. That wouldn't be allowed.
Okay, so this is the heart of my question that we're getting to. You said at one point, we need to determine whether it was intent or a mistake. And that sounds like a great idea in like the lawmakers' boardroom around a table, with coffee but out in the real world with real actual cases happening, do you really think that we're going to be able to determine with any sense of accuracy intent versus mistake?
You can't really focus in on that intent itself. You have to look more at the action, and that's what all of the other countries do. They make it up to the trial judge to allow the evidence into court or not. And that's because they don't really focus in on the mindset of the officer. They focus more on the action that was done. So if the policeman, like in the case of Coolidge, they made a mistake in where they got the warrant from. That doesn't really dictate that the officer was being intentional about that. That wasn't really a grossly negligent action. Gross negligence is actually a legal standard, which states that if the police, did something that violated people's rights, and it was pretty much the gross negligence of people's rights and of the law. So that's what they would have to determine, is that standard of gross negligence, which is applied in different court cases.
Okay. Do you have a follow-up? Because I'm continuing
Just a quick
a line.
follow-up about that one little point, and then I'll let you get back to yours. I actually do not remember this. Is gross negligence defined the same in civil law as in criminal law? And this is outside the scope of your thesis. I'm just wondering if you know that.
I don't think I have the exact answer to that question.
All right, that's okay.
But the legal definition that I had was that intentional disregard for rights and safety. It
Okay.
seemed like those were like the two standards.
I think
of it.
then that it is different. That sounds like a criminal
Yeah, that's more
definition
of a
to me.
criminal.
And then because you have a whole thing about negligence in civil law, tort law, that is, failure, omission, that kind of thing. So it sounds different to me. Okay, thanks.
Okay.
So Dwight Schrute on The Office said, better 100 innocent people behind bars than one guilty person walking free. Remember that quote?
I haven't watched too much of The Office, but I've heard of that.
I fear that right now officers, the current policy, the officers are crossing every T, dotting every I, making sure they're following the exact guidelines. I fear that this is going to be a step in the direction of...
Step in the wrong direction.
It's a step in the direction of officers being like, it'll probably be admitted anyway. There's no way they're gonna prove intent or prove gross negligence. I'm gonna be fine. Whereas right now, they know that if they don't cross every T and dot every I, their evidence is not gonna be admissible.
And that's the general mindset that follows the exclusionary rule, is that it kind of forces the police to be more thorough in their actions. But the whole philosophy of my second point, I think it was actually my first point, was that it really doesn't, effectively punish the police, and it doesn't effectively change their actions, because we saw in other countries, even in life-threatening situations, it seemed that training and correction was really important and effective in how the police conducted themselves. Because in all of these other countries, like in Germany, they trained for 3 years, and it just seems that correction and punishment are far more effective than this indirect punishment, kind of saying, if you do this, then we're going to let the criminal go free, and that'll make you feel guilty as a police officer. It's an indirect form of punishment. So in other words, it doesn't directly change the way that police would conduct themselves as effectively as, say, punishing the officer when they make a mistake, sanctioning or firing that person if they make a mistake, or training them to not make the mistake, or training them to not misconduct themselves again, which is not really done very often in the police force.
Do police officers favor this?
I actually haven't talked to many, but I talked to a few of the gentlemen downstairs who are the ones protecting the school. And one of the officers I talked to is how he kind of mentioned how society really, does villainize the police force, and how they are kind of seen as, and they're always treated as, the perpetrator in a court of law in many cases. So when I was talking to him, he was discussing how the police need to be essentially, the police can't be treated as the criminal in a court of law, because the person who has actually really committed egregious crimes needs to be the one who is more on trial. So I can't give a definitive answer as to if the police force itself is in favor of this, but I know that, some police officers do agree that society doesn't respect them enough.
Okay. So on the one hand, you have their evidence is more likely to be admitted into court.
Mm-hmm.
But on the other hand, instead of just having evidence dismissed, they get sanctioned or fired.
Mm-hmm.
So I was just curious which one they value more. But
Well, I think it's really what's best for society as a whole, because obviously it's good to look out for the police officers and do what's best for them. But when it comes to punishing society for their mistakes, I think it would be more important to train the officer or punish the officer rather than punish society in his place. So it might not be best for the police officer in that one instance, but it would be best for society.
Okay, so I'm going to take us on a little bit of a different track.
Okay.
Did you get to wind up your line of questioning? Okay.
Cool.
So you have what usually happens is you have statutes that are passed by Congress, right?
Mhm.
And you're talking about federal search and seizure laws, right?
Yes.
Okay. And then those statutes kind of trickle down. Well, we have those on the federal level. We also have them on the state level.
Mm-hmm.
So those statutes, those laws, which is what you're talking about,
Yeah.
it comes, Constitution and then statutes,
Mm-hmm.
kind of further, are we really doing what we said we were going to do in the Constitution?
Mm-hmm.
And then case law comes under that, where they put the statutes to the test and say,
Yeah.
is this really working out here in the real world?
Mhm.
Correct?
Yeah.
So I think what you're saying is that we've gotten to the point where this statute, this federal statute,
Mm-hmm.
has gone through case law and is actually now not working.
Mm-hmm.
So my question is, in saying all that, is that process I trust. I trust that process.
Mm-hmm.
I've studied that process, and
Yeah.
I am a original intent person from the Constitution. I'm a strict constructionalist. I don't apologize for that. I really want, because I respect the reasons that people put things into place at first.
Yeah.
And the very, back when our country started, and I respect the process where we've had to adapt all the way along while
Yeah.
preserving what was good about that. Okay, so back to my question, which is, are you saying you don't trust that process, basically? Or have we gotten to the point where we have the Constitution, then we've had statutes that came from that, then we've had case law that's trying to refine that, and now our exceptions are so far undercutting the original intent that we need to revamp we need to work backwards.
Yeah.
Does that make sense?
Yeah. No,
Okay.
I understand the question.
Okay.
So basically, the exclusionary rule, I'm kind of arguing, first off, doesn't really fulfill that purpose of criminal justice or how it was outlined in the Constitution. Because, see, the exclusionary rule is pretty recent. It was only made nationwide in 1967. Before that, a few states had it, many states didn't. And we saw that crime rates went up in those states that didn't have it once the exclusionary rule was nationwide. So as far as the whole process goes, I think that the exclusionary rule was put in for a good intent. Like the case of Matt versus Ohio, even though there was bad things that were found, it was not right or good for the police to just go into her home without a warrant or really a justification to do so. So in that case, I think that, yes, evidence should have been excluded. But the fact that it's now become so broad and it applies to cases where they just make the mistake, or they make a single mistake, or they make an issue and they make a mistake in following the process of criminal procedure, and then evidence is excluded, I don't think that's the way it was really intended to fulfill its purpose. It was really only supposed to protect in those cases of gross negligence, but it's really essentially grown to where it doesn't, and it's a broad solution now that really doesn't fix the specific issues that it was supposed to solve. So as far as that whole process goes, I think it's really gone through that process, and we've seen how it works in the real world, and we've seen how broad it is and how it's really causing more problems than it's actually solving. And if we made it more precise, then it would fulfill that original intent and purpose that it was actually put in place for.
Okay, so you're saying we have now reached diminishing returns, so a slight course correction in the case law area, case by case, isn't going to do us any good anymore because we've already beat that horse to death. We need to go back several steps and correct it that way.
I think that, so I can't quite wrap my head around the individual case-by-case law because I haven't done a lot of study. I haven't been in law school. I haven't done specific study into like what specific case law is, but I think that the encompassing broad nature of the exclusionary rule is like a nationwide problem that needs to be solved on a nationwide level.
Okay, good.
So your first point is that it's an ineffective deterrent.
Mm-hmm.
You actually said that it resulted in an increase in violations of privacy by police.
Yes.
That seems completely counterintuitive to me. So I would like to just sort of dig into the evidence a little bit. Can you tell me about the evidence that helped you form that conclusion?
Okay, so the whole point of this argument was essentially talking about the really, in my research of the exclusionary rule, people haven't really been able to look at the specific number and statistical effect in many cases. So it's really hard to essentially make that statistical distinction. But what I was using this study to essentially conclude is that when the exclusionary rule was ratified, the motions to suppress evidence increased significantly. So basically what I was saying there is that the police were still misconducting themselves with the exclusionary rule in place because people were still trying to get them to not use evidence in trial. So I wasn't necessarily saying that the police they were violating privacy more, but a lot of those increase in motions to suppress can be attributed due to the fact that the exclusionary rule was made nationwide at that point. But the main point of that argument was to say that the police still misconducted themselves at rates that didn't really decrease in any way, even when the exclusionary rule was made nationwide.
Okay, so what I just heard you say is that the evidence you used to form that conclusion may not have been as precise as presented. Is that an accurate statement?
What the study specifically said is that the results indicated significant increases for the motions to suppress evidence in narcotics and weapons offenses. So what I was drawing from that is saying that the police didn't lower their amount of misconduct when the exclusionary rule was put in place. But I mean, there wasn't necessarily a statistic or a precise statistic that presented.
Do you have any additional statistics that might show that this didn't have a decrease in
the police misconduct?
In police invasion of privacy and misconduct?
I mean, there were I really was able to look at this on a global level and look at other countries and where they don't have exclusionary rules, and there wasn't an extreme amount of police misconduct in those countries that didn't have exclusionary rules. But as far as the U.S. goes, there really wasn't a major study to show exactly how every state and how every policeman acted due to the exclusionary rule, because it's really difficult to precisely study that because jurisdictions change and are so varied from each other in the United States that you can't pinpoint one thing to the entirety of the U.S. police force. But what we can do is look at the way that police in general have conducted themselves due to the exclusionary rule, and this was really the only study that I could find that specifically referenced that.
Okay. Do you have another question?
I can ask one if you...
I have one.
Okay.
Okay, so you touched on this right at the end, this perception that police, now we've got a sort of PR problem with the police department, that they are evil, we've lost our trust in them.
Yeah.
That's a broader problem, right? How much did you go into that to say you know, are there other ways besides just your specific solution that can we address that underlying root cause that is there?
So I'm not necessarily saying that I can solve the society's
Right.
perception of the police, but essentially the best we can do is to try and change the way that law directly affects the police, because the law right now is kind of pushing and affirming that narrative of society that the
Right.
police are evil, because this law is essentially placing more mistrust on the police than the actual criminal.
Okay.
So
You're
not
proposing a
allowing-
partial solution or something that would further a solution to a bigger problem.
Essentially, in this
Okay.
case. But that wasn't the main issue I was really
Right,
looking
right.
at. That was one of them that could be affected by this.
Okay.
So,
You did an excellent job.
thank you.
Yeah.